Hello, everyone, and welcome to One Civil Law. Hope you're having a great day. For anyone who might be joining me from Viva's stream, whatever the heck that was super entertaining. And we are here with another edition of Stupid Lawyer Letter Time, and possibly Stupid Lawyer Time, maybe both, but mostly here we're Stupid Letter Time. And I have not read this letter yet. I didn't get past the title and subtitle, but I knew immediately it was for me. So I want to share my feelings with you. Very exciting. Give everyone a chance to filter in a little bit. So today's Stupid Letter Time comes to us courtesy of The Atlantic, which wrote in its title, Beyond Originalism. Beyond Originalism. It's like, okay. The dominant conservative philosophy for interpreting the Constitution has served its purpose, has it now? And scholars ought to develop a more moral framework. Well, that's as far as I got before I decided I had to share this with you. And we're just going to be criticizing it as we go. So the phrase "more moral framework" suggests that originalism is a moral framework of some description, right? Because that would make something more moral, but it is amoral framework, non-moral framework. It's not a moral framework. It's a legal framework. The law and ethics and morality are different concepts, different things. So like right off the bat, we're on a bad place. So let me tell you a little bit about originalism and what it is and what it means. So basically, the long story, the too long didn't read version of what originalism is when we're interpreting a statute or a constitution or a regulation or any provision of law, whatever it is, we are interpreting it using what it meant the day it was written, right? Because if Congress is writing a law today, right, they are people who are writing it with particular purposes and meanings in mind. The language that they use means a certain thing now. English may evolve. English has evolved. Anyone ever try to read like Old English? You know, it's basically undoable. So like what terms mean and what words encompass is not the same now. It won't be the same tomorrow as today, and certainly won't be the same 200 years from now. So when we're trying to interpret something, we look at it at the day it was written. Right? That is our framework. That is originalism. What governs is what Congress or the legislative body or the regulatory body or whomever it is writing this, whether it's constitution or statute or whatever, what it meant that day it passed. Okay? That's originalism. And then originalism comes in a couple different flavors of originalism. We have the textualists, and the textualists, which I lean to be a textualist. I wouldn't consider myself hardcore textualist, but I definitely consider myself leaning textualist. Lean textualist is that what governs is the black and white words. You know, that the words are what matter, not so much what Congress meant or intended or hoped for or their purpose, but what they wrote. What governs is the language. You know, lawyers use language. And so what they may have wanted in their own head is not as operative as the text. Okay? So I've now explained originalism. I've explained textualism. Great. Let's move on. So let's read this. And like I shouldn't have to explain. I really shouldn't feel like I shouldn't really have to explain why rolling in morality into law is a bad idea. But I'll do it anyway. Because if I put in my morality into law, then I'm just writing the law. You know, I'm just putting what I think is the moral good. So never mind what Congress did. I'm going to do what I think is moral. Anyone see any problems with that? Yeah. So, this stupid letter comes from Adrian Vermeerl, professor of constitutional law at Harvard Law School. I am now going to law-splain to a professor of constitutional law at Harvard. Excellent. Let's give this a go. I'll scroll in a little bit more. Okay. In recent years, allegiance to a constitutional theory known as originalism has become all but mandatory for American legal conservatives. That's a fair statement. I mean, I wouldn't phrase it quite that way, but since it was basically invented, it has become more and more dominant and more adopted by conservative legal thinking. And so at this point, originalism is pretty much conservative legal thinking, pretty much. So, not the way I'd phrase it, but okay. Every justice and almost every judge nominated by a recent Republican administration has pledged adherence to the faith. Well, it's not an issue of faith. It's an issue of modes of interpretation. It's default rules. It's rules. It's rules behind the veil, if you like, right? Before we peek behind the veil, we have a bunch of rules that will guide us. And that way, what we see on the other side of the veil won't taint our rules, right? So we form the rules in the abstract so that when we go apply them to the case, we'll come out with the right decision. We won't be jaded or unduly influenced by the case in front of us, So, like, for example, we would, behind the veil, as it were, agree that we should give due process, agree that, cops, when they break certain procedures, evidence should be thrown out, right? We could agree on these kind of things. But then we would come to the moment of truth, right? Where we open the veil and we suddenly realize it's, a person who's dead bang guilty, but, because of certain things in the law, they have to be released. And so, like, what do we do, right? Because we applying our principles, we should let this person go. But our own morality says convict them. Well, one of the reasons we form this principle is specifically to save us, so that we don't have to make these decisions on the fly. So it's not like an issue of faith so much as an issue of, I'm going to come up with a set of ethics or a set of rules that I can apply regardless of the situation, and I know I'll be okay. Right? This is how I'm going to approach things. I'm just going to follow the process. The process will save me. Product by process. We follow the process, it gets me where I want to be. Right? At the Federalist Society, the influential association of legal conservatives, yes, speakers talk and think of little else. A slight exaggeration, but yeah, the Federalist Society talks and thinks about this quite a lot. And they've been talking and thinking about it for like 50 years. Quite a lot to talk about, yeah. Even some luminaries of left liberal legal academy have moved away from speaking about living constitutionalism. Yeah, to a conservative, this is madness. Living constitution is madness. No, it's not living any more than statutes living. Congress wrote a statute today, right? They wrote a statute today. It means a certain thing today. The idea of statutes living is what are you talking about to us? Fundamental fairness. Again, conservatives don't raise those kind of questions. What is, the idea of what is fair, we could talk about endlessly. There's a great course at Harvard, which I've watched multiple times because it's available online, by Michael Sandel, called Justice, and basically going like, what is justice, and many different theories of justice. So like, yeah, what is fair or what is just depends on your framework. But to a conservative, it's like, what is just is doing what the law requires or what the law says. And it's like, it's up to Congress to figure out what the law should be. Judges just to figure it out what they meant. Okay. And evolving standards of decency. Again, conservatives don't think along these lines. If you want something because we've evolved standards of decency, to a conservative, the answer is easy. Go pass a new law. Pass a different law. We're not saying you can't have evolving standards of decency. That's fine. Just go change the law. That's all. Don't get a judge to do it. Why are we the ones who are supposed to be doing it? And have instead justified their views in originalist terms. One hears the catchphrase, we're all originalists now, which I think Kagan was someone who coined that phrase among the left-leaning bar. But how loyal she's been to that, it's like, questionable at best. Originalism comes in several varieties. Baroque debates about key theoretical ideas rage among its proponents. Yes, and I was trying to talk to you a little bit about this when I was trying to lay out how I said it comes in different varieties, and I laid out one of them, textualism, which is one I lean more to. It's the text is what governs. But you could also look to other things like original meaning or original intent. but these things are a little bit more washy. What's not as washy is the black and white text. So, all else being equal, I prefer text. I'm not as strict about it as the strict textualists, because, the text doesn't always tell us everything, for at least reasons that Congress doesn't always know what they're doing. But, all else being equal, it governs. Yeah, fair enough. But their common core is the view the constitutional meaning was fixed at the time of the Constitution's enactment, or the time the statute was enacted, or the time the regulation was enacted. This is not like exclusively a constitutional theory. This is a theory of law, period. All of the law, right? All the law should be interpreted when it became into effect. Okay. This approach served legal conservatives well in a hostile environment in which originalism was first developed and for some time thereafter. Yeah, when the conservatives first came up with this idea, it was not well accepted in the academy. And Justice Scalia, more than anyone else, is the person who basically converted the entire conservative bar into what it is now. So Justice Scalia is, essentially the patriarch of this thing at this point. He wasn't the one who invented it, but he was the one who preached it and the one who converted everybody. So, okay. But oh my God, we're going to have good times. But originalism has now outlived its utility. I'm sure you'll tell me all about it. It has become an obstacle to the development of robust, substantially conservative approach to constitutional law interpretation. Okay, such an approach, might one call common good constitutionalism, should be based on the principle that government helps direct persons. That is not a principle necessarily of conservative legal or political thinking. The idea of the government helping people is not necessarily a tenet of conservative legal or political thinking. One of the things that conservatives will talk a lot about, especially in more political thinking, is what's called negative liberty. One of the things that the government should do, and depending on who you ask, the only thing government should do is keep out of your way and not take stuff from you, right? They should not inhibit freedom of speech. They should keep the order and otherwise just stay out of the way. So the idea that the government should be providing anything to anyone is not a common core idea, especially among conservatives. The idea that the government should be doing anything for somebody is not a principle of conservative thought. I mean, conservatives can certainly believe it. There are conservatives who certainly do, but it's not it's not a central tenet of conservative thinking. Should be help also associations and society generally towards the common good. Good luck on trying to figure out what the hell that is. And the strong rule in the interest of attaining the common good is entirely legitimate. Conservatives don't really have an objection to a strong rule in the attainments of the common good. They just think the legislature should do it. That's what we want to do, then that's fine. Get the legislature to do it. That's what you do. That's why we have elections. In this time of global pandemic, oh good, this person is calling for a complete revolution of the state because of that. That's great. I feel like you can really see in trying times, people, their colors really come out. So this person wants to turn the state into something completely different. They want to use this current situation as an excuse, All right. The need for such an approach is all the greater. The need for such an approach is all the lesser, I would say, because it's this is how tyranny starts, at least according to conservative thought. As become clear that just a governing order must have ample power to cope with large-scale crises of public health and well-being. So they're saying that it is necessary for the government to provide health care, is the way I'm reading that, which again is not a conservative thought. Reading health in many senses, not only literal or physical, but also metaphorical and social. Well, that sounds like giving the government a shit ton of power. Give the government the power to promote health in the sense of literal, physical, metaphorical, and social. That's not dangerous in any way. This is a professor of constitutional law at Harvard. Okay. Alternatives to originalism have always existed on the right, loosely defined. That's true. One is libertarian, or classic liberal constitutionalism, which emphasizes principles of individual freedom that are often in uneasy tension with the constitutional original meaning and foundational generational norms. Right. So the idea of classic liberalism or libertarianism is, as the government should stay out of your way. But I don't think it's that much in tension, because, most of the rights of the Constitution are negative liberties. Congress shall make no law. Congress shall not infringe. They're not things Congress is supposed to do. They're things that Congress is supposed to not do. So it's not really in tension. Originalism and libertarianism probably do have some tension points, but a lot of libertarian ideal is baked into the Constitution. So there's not that much tension, it seems to me, off the surface. Okay. The founding era was hardly libertarian on a number of fronts that loom large today, such as freedom of speech and freedom of religion. That's true. This is a bad thing. Consider that in 1811, the New York courts, an opinion written by the influential early jurist Chancellor James Kent, upheld a conviction for blasphemy against Jesus Christ as an offense against public peace or morals. Well, Matthew, you should be able to get this one. This is a good one for you, Matthew. Why did the decision come out that way, Matthew? Do you want a hint? Why the decision came out that way? I'll read it again for you. Consider that in 1811, the New York courts, an opinion written by the influential early jurist Chancellor James Kent, upheld the conviction for blasphemy against Jesus Christ as an offense against public peace and morals. Okay, Matthew, why did that decision come out that way? Why did that decision come out that way? Do you want a hint? Matthew? Let's give Matthew a chance to type. I'll read it again for you. Consider that in 1811, the New York courts, in an opinion written by the influential early jurist Chancellor James Kent, upheld a conviction for blasphemy against Jesus Christ as an offense against the public peace and morals. Matt, I know you got the answer to this question. I believe in you, Matt. Why did that decision come out that way? Do you want to have? Let's give Matt a hint by highlighting the important words that will reveal the answer. Ready? I've highlighted it. Matt. Consider that in 1811, the New York courts, in an opinion written by early Chancellor. Matt, what changed between 1811 and today? What changed between 1811 and today? That this decision would not come out the same way today. 1811 was the clue, Matt. Now, pre-Constitution isn't the right answer, but pre what? Matt, I know you know this one. Come on. Come on, Matt. Come on. Freedom of religion didn't apply against the states in 1811. Freedom of religion didn't apply against the states in 1811. Matt doesn't know the answer. All right, Matt doesn't know the answer. I'm going to help you out. Freedom of religion didn't apply against the states in 1811. That's the answer to the question. Because the 14th Amendment hadn't been created yet. That's why. Yeah. The 14th Amendment hadn't been created yet. So the Federal Bill of Rights only binds the federal government. So Congress shall make no law. It's right in the First Amendment, guys. Didn't you read it? Congress shall make no law. The First Amendment only applies to Congress, which is to say the federal government. The 14th Amendment hadn't been invented yet. So the reason that this decision comes out this way in 1811 is because the 14th Amendment, which through the process of what we wonderfully call incorporation, didn't exist yet. So this decision in 1811 wasn't incorrect because the First Amendment didn't exist as it applied to New York. Yep. That was the answer. It was right there. It was right there. 1811 was the answer, Matt. But now you know. That's okay. All right. Another alternative is the Burkean provision, which tries to slow the pace of legal innovation. Okay, here too the difference with originalism is clear because originalism is sometimes revolutionary. Considering the court's originalist interpretation, declaring constitutional right to own guns, a startling break with court long-standing precedent. Well, I won't agree with that. I will agree it's a startling break with the Court of Appeals precedent, but the only real precedent from the Supreme Court was Miller, and we read Miller, and Miller is a dumpster fire. So I don't think it's a startling break with the court's precedent. If you want to say it's a startling break with the Court of Appeals precedent, then okay, I'll agree with you there. But it's what the Constitution seems to clearly require. I mean, I'd cite you law review articles that say this all day long, but what's the point? You know this. I got big beer, baby. I got big beer. Yeah. Big beer. Yeah. All right. These alternatives have scattered adherents, but originalism has prevailed, mainly because it has met political and rhetorical needs of legal conservatives struggling against an overwhelmingly left liberal legal culture. Also, we just kind of think it's right. But yes, it has allowed us to hold our own against the left. The left has a nice hold on academia in general, but the conservatives are holding their own in the law, and they're holding their own because of this stuff. Yeah. The theory of originalism, initially developed in the 1780s, that's roughly right, enjoyed its initial growth because it helped legal conservatives survive and flourish in a hostile environment, all without fundamentally challenging the premises of legal liberalism that dominate both the courts and the academy. Okay, fair enough. It enabled conservatives to oppose constitutional innovations by Warren and Burger, appealing over the heads of the justices to the purtative, true meaning of the Constitution itself. Which is fair enough, because I doubt that this author would disagree with the premise that the Supreme Court can sometimes get the Constitution wrong. They're right because they're final and all that stuff, but occasionally they get it wrong. So yes, we can go over the heads of the justices and say, no, you actually got the interpretation wrong, as I have many, many times on this channel. Quite a lot. Working for Filburn and Chevron and Brand X and Auer and slaughterhouse cases, and I can go over the heads of the justices and say, no, you got it wrong. You got it wrong. Yeah, it's okay to disagree with them. Let's see. Yeah, we don't allow people to insult each other. Matt's right. We don't really allow people to insult each other. So agree, disagree, but don't insult people. It's not. Yeah, it's one of my rules. Just don't insult people. It's okay to agree. It's okay to disagree, but don't insult people. So I don't know the degree to which Matt is a constitutional or scholar or not, but there's no real reason to denigrate him. Doesn't help anything. When in recent years legal conservatives has won the upper hand in the court and judiciary generally, originalism was national coordinating point for the creed, something to which political nominees could pledge their fidelity. Sure, we came out with a central theory of construction that made sense. We've been applying it for about 50, 60 years, and it's been working for us, and so we want to keep doing it because it keeps working for us. And we find a lot of intellectual purity in it, you know? We all learned from Schoolhouse Rock, like I'm just a bill sitting here on Capitol Hill waiting for Congress to pass me. Well, Congress, when they're writing that bill, presumably had something in mind. So to give faith to Congress is to give faith to the words, whether it's the Constitution, text, statute, regulation, whatever, right? Treaty, all that good stuff, You know, fine enough. Circumstances have now changed. Please tell me more. The hostile environment that made originalism useful rhetorical. Yeah. Don't throw shade, okay? I don't want to time you out for throwing shade. We don't allow insults here, okay? It's just not helpful, right? There's no reason for the ad hom, right? I was playing with Matt a little bit. I don't think I was ad hominem about it, but and then Matt could tell me if I was over the line. But there's no reason to denigrate. So let's keep it civil. Circumstances have now changed. The hostile environment that made originalism a useful rhetorical and political expediency is gone. No, it's really not. It is not gone in any way. You may argue that conservatives at the moment have the upper hand, but to argue the hostile environment's gone, it's like no, there's still a lot of people who love it and would want to bring it back, including presumably you, author. I mean, I not to put too fine a point on it, but it sounds like you want to go the other way. So it's like there's some hostility. And you are a constitutional professor at Harvard, so you are part of the environment of the legal education. So you are hostile to us. So there's that. Outside the legal academy, at least, legal conservatism is no longer besieged. I don't know the degree to which I can or cannot agree with that. I mean, it depends a little bit what you mean by legal academy. If you mean the law schools as such, then maybe. Although I could argue the judges are still hostile to it, or a lot of them are. If you include the judges as part of the legal academy, which I suppose you could, then I guess. But outside the legal academy in the broadest sense, no one knows about this stuff. Not a lot of non-lawyers are paying a lot of attention to this stuff because this is a legal thinking. So outside the academy, I'm not really sure there's If Donald Trump is reelected, some version of legal conservatism will become the law's animating spirit for a generation or more. And particularly if we get the RBG seat and we replace it with Amy Coney Barrett. Yep. And even if he's not, the reconstruction of the judiciary has proceeded far enough that legal conservatism will remain a potent force, not a beleaguered and eccentric view. Well, it probably won't be as eccentric, but I think it will be beleaguered. Assured of this, conservatives ought to turn their attention to developing new and more robust alternatives to both originalism and left liberal constitutionalism. Well, I mean, not to put too fine a point on it, but you could offer some alternatives, which perhaps you will at some point in this article, at which point I will either accept them or laugh at you, but we'll find out. But this entire philosophy of thinking, it's a pretty well-contained theory. It's the idea that words mean what they meant when they were wrote, and the ideas behind them meant what they mean when they wrote. And if Congress uses a word 50 years ago, it may not mean the same thing it means today. So seems reasonable. It is now possible to imagine a substantive moral constitutionalism. Okay, that although not enslaved to the original meaning of the Constitution, is liberated from the left liberals' overarching sacramental narrative. This person does understand that if we put in place a moral imperative on top of the Constitution, it would be a conservative moral imperative. They do understand that, right? If the conservatives are the one inventing it, and they want to impose a moral constitutionalism on this, then the morals they would be doing would be right-leaning morals. They do understand this, right? They do understand that if the conservatives were to take them up on their offer, that they'd be imposing right-leaning morals. They do understand that, right? Doesn't seem to have occurred to them. Very sad. Alternatively, in a formulation I prefer, one can imagine an illiberal legalism that's not conservative at all. Insofar as standard conservatives is content to play defensively within the procedural rules of the liberal order. I don't even know what that sentence means. Yeah. Presumably Jacob meant black diamonds, but it could have been better phrased because you're talking about skiing. So presumably he meant black diamonds, but it could have been better phrased. This approach should be taken as a starting point, substantive moral principles that conduce to the common good. Principles that officials, including but by no means limited to judges, should read into, the majestic generalities and ambiguities of the written Constitution. These principles include respect for authority of the rule and rulers, which would presumably give authority to Congress, respect for hierarchies that society needs to function. I didn't think the left believed in hierarchies. Solidarity within and among families, social groups, and workers' unions. Those are policy points of view. Trade associations and professions. Appropriate subsidiary or respect of legitimate roles of public bodies and associations at all levels of government and society, and challenging willingness to legislate morality. From the bench. From the bench. Do you really want to give? Do you really want to give the right wing the impetus to do this? Do you really want the right wing to start imposing moral judgment on you? Let's let that sink in for a bit. To be sure, some have attempted to ground an idea of common good on originalist understanding, taking advantage of natural right orientation of founding error. Yet, the approach leaves originalism in ultimate control, hoping the original understanding will happen to have moral appeal. I'm talking about a different, more ambitious project, one that abandons the defenseless crouch of originalism. Okay, so you want the conservatives to abandon originalism completely, so you want to be completely unmoored from like any sort of text and go just directly to what the right wing thinks morally should be the case. That doesn't sound like that's a problem in any way. I'm talking about, Ronald Dworkin, legal philosopher and scholar, used to urge moral readings of the Constitution. Common good constitutionalism is methodologically Dworkian, but advocates a very different substantive moral commitment priorities, which are conventionally left liberal bent. So you want to impose right-leaning bent. Okay, that's just like common good constitutionalism is not legal positivism, meaning it's not tethered to a particular written instrument of civil law. Wow, that's good. So it's not tethered to the written instruments. Wow. Jesus Christ. You want judges to be kings. Holy shit. Holy shit. It's not tethered to particular written instruments or the will of legislatures who created them. Holy God. we just want to completely abandon we want to do everything from the bench. We're not tethered to those documents or the legislature. Holy shit. Instead, it draws upon an immemorial tradition that includes, in addition to positive law, sources such as the Ius Gentium, the law of nations or general law common to all legal systems. So you want to like impose an international law system. Good luck with that. And principles of objective natural morality. You believe in objective morality? That's interesting. Including legal morality in the sense used by American legal theorist Lon Fuller. The inner logic of activity that law should follow in order to function well as law. All right. Common good constitutionalism is also not legal liberalism or libertarianism. Its main aim is to, well, it would be legal liberalism or libertarianism if those kinds of people were judges. They would be indistinct. You say common good constitutionalism is not legal liberalism or libertarianism. It would be if those kinds of people were judges, because those kinds of people would be imposing those kinds of moralities. Because I've definitely heard enough libertarians talk to know that they think it's a moral proposition. So they think it's a moral proposition. So if you don't think that they'll impose this as a moral proposition, I don't know what you're talking about. Its main aim is certainly not to maximize individual autonomy or minimize the abuse of power, an incoherent goal in any event. To maximize autonomy or minimize power. Okay, so we don't concern about liberty or power. That's good news. But instead, to ensure the ruler has the power needed to rule well. The ruler has the power to rule, to lead. So you want to give Donald Trump massive power to impose on a moral framework, irrespective of those pesky statutes. Okay, that's an idea, I guess. A corollary is to act outside or against inherent norms of good rule is to act tyrannically, forfeiting the right of rule. But the central aim of constitutional order is to promote good rule, not protect liberty as an end unto itself. Wow. A corollary that is to act outside or against inherent norms of good rule is to act tyrannically. So it's tyranny if you're acting outside norms of good rule. But what's good rule? I don't know. It's not, constraints on power are good only derivatively, insofar as they contribute to the common good. The emphasis should not be on liberty as an abstract object of quasi-religious devotion, but on particular human liberties whose protection it is a duty to justice or prudence on the part of the ruler. What the hell is this person talking about? Finally, unlike legal liberalism, common good constitutionalism does not suffer from a horror of political domination and hierarchy. Because it sees the law as parental, a wise teacher, and inculcator of good habits. Wow. Okay, that's what are we talking about? We want judges to just start imposing things like, we want judges to just like overrule the king, we want judges to be kings. I mean, I'm trying to be fair to this person, but it sounds like you want judges to be kings. Just authority and rulers can be exercised for the good of subjects, if necessary, even against subjects' own perception of what is best for them. Well, I don't necessarily oppose the concept of doing things that the people don't believe are in the best interest of them, but I do think we should do it in a Republican way, a little R Republican, with voting and elections with Congress. I don't think we should have judges like imposing what they think is best, even against the subject's own perceptions. Perceptions that may change over time anyway, as law teaches, habituates, and reforms them. What the hell is this person talking about? I'm struggling to give this a fair interpretation, and I don't know what is going on. Subjects will come to thank the ruler whose legal strictures. Wow. I also like how we're using the word subjects, because the word subjects is definitely a word we use in a Republican form of government as opposed to citizen. So we're going to use the word subjects. We're subjects to the king. Great. Subjects will come to thank the ruler whose legal strictures, possibly experienced at first as coercive, encourage subjects to form more authentic desires for individual common goods, better habits and beliefs, and better track and promote communal well-being. The people will thank me in the end, man. This person is a despot. This person is a despot. They want the king to speak from on high for the greater good of what is good for everyone, which I suppose is good as long as you have a good king. You know, I'm not the biggest history expert on kings, but you know, I do know that in the grand history of kings, there have been absolute monarchs who have been fairly good kings and have done well and right by their people. You know, we could obviously quibble on finer points, but there have been some good kings over the years. And by over the years, I mean over the centuries / millennium, right? So, like, you know, the best form of government probably is the benevolent king. That's probably the best form of government because, you know, it's benevolent and he doesn't have anything to get in his way, and so he can just do it. The problem is the benevolent king is almost inevitably at some point followed by the not so benevolent king, and then everything goes completely to shit. So, you know, we don't really want to create a rule or system where it's like, if only we had a benevolent king, even if that's in the form of judges, if only we had a benevolent king, they could do things that would be for the good of us, and we wouldn't have to worry about those pesky laws or pesky things written down, or things, and the fact that people wouldn't like them. We'll just do them, and that people will love us in the end. You know, I know too much from history to know that while there have been some good kings, there have been some really shitty kings, and you know, I don't really want to take the bet on that one personally. That's not scary in any way. Yawn, as long as the king is good. As long as you have a good king, kings are great. But when they're not so good, you know, I don't even know what that would mean. Pay me to review separation of powers. I've said that I'll do a review of a particular case for $20, but I don't even know what that means to review. Like, what would it mean to even review separation of powers? What is that even? What are you even asking me to do? You want me to read the Constitution? I've done that before. I've done that on stream. Common good constitution draws inspiration from early modern-day theory of reason of state, which, despite the connotations that become attached to the name, is not at all a traditional of unsuspicious machination. It's formulated precisely to combat amoral technocratic visions of rule as maximations of princely power. Instead, the Reina di Stato, which presumably is a statute that we can just ignore because that's what we're doing now, elaborates a set of principles of just exercise authority. Promoting a substantive vision of good is, always and everywhere, a proper function of rulers. But we live in a representative democracy. Why don't we just elect different rulers? You know, you may not like Trump, but he's not king. We can elect someone else. You know, I don't know what's going on. Every act of the public regarding government has been founded on a vision. Any contrary view is an illusion. Liberal and libertarian constitutional decisions that claim the rule for morality as a ground of public action are incoherent, even fraudulent, for they rest on merely a particular account of morality, an implausible account. So there is apparently in the ether, there apparently is in the ether a plausible account of morality, which is not a liberal or libertarian view of morality. But this author knows what the proper view of morality is, and so he is going to impose it through the just and wise king. Given that it's legitimate for rulers to pursue the common good, constitutional law should elaborate subsidiary principles that make such rules efficacious. Constitutional law must afford broad scopes to rulers to promote, as the Ragnan de Statio put it in famous Trinity principles, peace, justice, and abundance. Today we may add health and safety to that list in very much the same spirit. In a globalized world that relates to the net, so he likes globalization. So apparently we're doing a one world king government. That's good. In a globalized world that relates to national and biological environment in a deeply disordered way, a just state is a state that has ample authority to protect the vulnerable from the ravages of pandemics, natural disasters, climate change, and from underlying structures of corporate power that contribute to these events. Because the Ragnan de Statio is not ashamed of strong rule. Yep, we're going full bore authoritarianism. It does not seem presumptively suspect in the way liberalism does. A further corollary is that authority and hierarchy are also principles of the Constitution. Finally, and perhaps most importantly, just rule emphasizes solidity and solidarity. Authority that is held in trust and exercised for on behalf of community and subsidiary groups that make up a community, not for the benefit of individuals taken one by one. This is like the most insane article I've ever. This was written by a law professor at Harvard. This is written by a constitutional law professor at Harvard University, who apparently wants to bring on a king. How, if at all, are these principles to be grounded in the constitutional text and conventional legal sources? The sweeping generalities and famous ambiguities of our Constitution, an old and in places obscure document, afford ample space for substantive moral readings, so we can just impose on it, that promote peace, justice, abundance, health, and safety by means of just authority, hierarchy, solidity, and subsidiary. The General Welfare Clause, which gives power to promote the common defense and general welfare, is an obvious place to ground the principles of common good constitutionalism, despite a liberal tradition of reading the clause in a cramped fashion. So we want to read it in an open fashion. That sounds good. As well as the Constitution's preamble with reference to general welfare to perfect the Union and to justice. Constitutional words such as freedom and liberty need not be given libertarian readings. Well, they should be given Orwellian readings, I guess, instead. Instead, they can be led right on a better conception of liberty as the natural human capacity to act in accordance with reason and morality. Wow, this is a lot. This is a lot, man. This is a lot. That's better. Jacob asks, do you think every elected official has a duty to interpret the Constitution absent strict reading from Scotus? Yeah, I mean, every elected official has to take an oath of loyalty to the Constitution, and the Supreme Court certainly hasn't spoken on every conceivable question. So, I mean, I mean, for no other reason than practically, when the Congress is contemplating a new statute, if Congress is contemplating a brand new statute, obviously there's not a Supreme Court decision to speak on it because it doesn't exist yet. So they would have to, in the first instance, figure out what the Constitution should mean with respect to it. Now, of course, they could be wrong, but they should, at least in principle, apply it. So it makes sense to me. Lawful massive stream in 5 minutes, 40th birthday. I'm streaming, man. I'm streaming. I mean, Leonard and I don't coordinate on our times. We just do what we want to do. So if you want to go watch Leonard's stream, well, go watch it. I'm busy over here. Does an elected duty have duty to follow the laws as a written absent decision from the Supreme Court? Well, that's more complicated. Um, I suppose if I suppose if it's blatantly unclear that they're unconstitutional, presumably no, because like every official has a obligation to obey the Constitution. So like if Congress were to pass something that was like blatantly unconstitutional, then I suppose a federal official would have a duty to ignore it. But absent that, then probably not. But so I mean, there's some. I mean, every federal official has a duty to the Constitution, right? You have to take an oath to the Constitution first and foremost. So, like, if Congress screws the pooch, then I guess, in principle, can the president skip the line for Supreme Court review? I mean, not really. No, no. I mean, not in particular. I don't even know what that means. But I mean, they can certainly consider certain things at certain times and whatever. All right. The Supreme Court, like Congress and the presidency, is often drawn upon broad structural and natural law principles to determine the authority of the state. Police power, which despite its misleading name, refers to general power of the state government to protect health, safety, and order in public morality, is nowhere mentioned in the Constitution. That's fair. It's not, because it's a reserved power. The police power is in the broadest possible conception all the power of government. So the police power is just all the power in the broadest possible sense. So like, there's no reason to mention it because the Constitution's like divvying up parts of it. And so like, whatever is left is then just police power. So that's going to be fine. This is not an occasion to offer a bill of particulars about how constitutional law might change under this approach. Yeah, heaven forbid. But few general broad strokes can be sketched. The court's jurisprudence on free speech, abortion, sexual liberties, and relay marriage will prove vulnerable to under a regime of common good constitutionalism. Yes, it will. It absolutely will, because these are obviously moral issues to some degree, and of course they'll be vulnerable. The claim from notorious joint opinion of Planned Parenthood versus Casey is that every individual may define one's own concept of existence, meaning of the universe, and mystery of human life should not only be rejected but stamped as abominable. The claim from Casey that each individual may define one's own concept of existence, meaning of the universe, and mystery should not be stamped as abominable but beyond the reach of acceptable hereafter. So the concept that an individual has the right to define one's own concept of existence and meaning of the universe is an idea that is so abhorrent it should be struck down and barred from ever being considered ever again. Jesus, holy Christ. Jesus, holy Christ. Jesus, holy Christ. Wow. The claim from Casey that every individual may define one's own concept of existence, meaning of the universe, and mystery should be rejected but stamped as abominable. So you and I, as individuals, now have it is abominable to even conceive of the idea that we might define our own existence as a meaning and mysteries of human life. We have no self-government. Who the fuck wrote this thing? Jesus Christ. Jesus Christ. That sentence makes my skin crawl. Lord. The libertarian assumption central to free speech and free speech ideology. The government is forbidden to judge the quality. Wow. 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 I can scarcely not even believe the words I'm reading. I can scarcely not even believe the words I'm reading. So too, that would be to stamp as abominable. So too, should the libertarian assumption central to free speech law and free speech ideology, the government is forbidden to judge quality, moral worth of public speech. The one man's vulgarity is another man's lyric, and so on fall under the axe. So the idea the government can judge the quality and moral worth of speech. it's hard for me to like truly like conceptualize how evil an idea that is. This is evil. This is evil. This is as long as I have this power, apparently through moral constructionism as King Blackleaf, because apparently I've ascended to the throne of whatever. As long as I have the power to do this, I find this idea morally apparent, which is exactly the reason why I shouldn't have the power. No, I strike this down. It's morally apparent. This is Jesus Christ. Libertarian concepts of property rights and economic rights will also have to go, insofar as they bar the state from enforcing duties of community and solidarity in the use and distribution of the resources. Oh, I see. We have gone full communist manifesto over here. We have gone full communist manifesto over here. I'm sorry, the ball was hidden from me for a little bit there. But yeah, we've gone full bore communism. The idea of speech can be regulated by the state in the name of the moral good. Property rights can be regulated and redistributed as moral good. So yeah, we're straight into full bore, 100% full fat communism now. The government has the ability to impose moral sense. People don't have the right to define for themselves a moral sense. The state defines it for you through the just leader of the king, who has the power to redistribute all property, and you don't have the right to think anything about it differently. So we've gone full fat, 100% authoritarian communism. So we are well deep into the commie land. We are deep into commie world. Deep into commie world. Free speech ideology, property rights, economic rights, they're all gone. The ability of an individual to define one's concept of existence, meaning the universe and the mystery of life, is an abomination. Jesus Christ. Watch the caps. This is evil. This is fucking evil. This is evil. This is garbage. This is garbage. This is repugnant to everything. And have we been reading Marx recently? Have we been rereading the Communist Manifesto again? I told you not to do that. Jesus Christ. I've read things from the Atlantic before. I'm not sure I've ever read anything whatever this is from the Atlantic. I'm not sure I've ever read anything this from the Atlantic. This is, wow. Jesus Christ. But it's okay. I can subscribe to the Atlantic for $1 a week. There's a little banner ad at the bottom of my webpage, which you can't see. Enjoy unlimited access to the Atlantic for less than $1 a week. I don't think I'm going to be doing that, Atlantic. No. As for the structure and distribution of authority within government, common good constitutionalism will favor a powerful presidency ruling over a powerful bureaucracy. So, yeah, we definitely want an all-powerful state, which makes sense. The latter acting through principles of administrative laws, inner morality. Administrative law has an inner morality? I mean, we've read a fair amount of administrative law cases on this channel. I don't know that I thought that it had a morality really of any kind whatsoever. It is morality? The bureaucracy will be seen not as an enemy, but as a strong hand of legitimate rule. This is depressing, man. The state is to be entrusted with the authority to protect the populace from the vagaries and injustice of market forces, which is just as well because, we won't have a market anymore because we have centralized everything. From employers who would exploit them as atomized individuals, which, that's what individuals are. They're atoms. Individuals. And from corporate exploitation and destruction of the natural environment. Unions, guilds, and crafts, cities and localities, and other solidarity associations will benefit with the presumptive favor of law, as will the traditional family. Yeah, we've definitely seen these things benefit in the communist regimes. In the virtuous solidarity, the aim of rule will be not to displace these associations, but help them function well. Elaborating on common good principle that no constitutional right to refuse vaccination exists. Well, we read cases on that. We saw a case from 1905 on that issue. So you don't need to like upend everything to do that. You just cite that, was it called Morrison, I think was the name of that case. New Jersey, 1905. So we're already there. We don't have to like upend the entire order. Constitutional laws will define in broad terms the authority of the state to protect the public health and well-being, protecting the weak from pandemics and scourges of many kinds. Not from famine and strife and oh my, holy shit. Biological, social, and economic. Even when doing so requires overriding the selfish claims. Wow. Even when doing so requires overriding the selfish claims of individuals to private rights. Thus, the state will enjoy authority to curb the social and economic pretensions of the urban gentry liberals, who so often place their own satisfactions, financial and sexual. How did sexual get into this? What are we talking about? What? And the good of their class or social milieu above the common good. You have nothing to lose but your chains, my brethren. You have nothing to lose but your chains. In this sense, in case, by the way, to answer the question again, this is the author at the bottom. Adrian Verimel is the Ralph S. Tyler, professor of constitutional law at Harvard Law School. In this sense, common good constitution promises to expand and fulfill new circumstances with new emphasis, the constitutional commitment to promoting general welfare and human dignity. Yeah, that's definitely things communists are well known for. Overall, constitution will become more direct, more openly moral. I want to die. Less tied to tinnitus, law office history, and endless litigation of dubious claims about events a century in the past. Originalism has done useful work and now can give way to new confidence in authoritative rule for the. Wow. I'm not sure. I'm not sure I ever have disagreed with anything as much as I disagreed with that. You know, when I saw this title, I thought this might be a little bit more fun, but this became just unbelievably disturbing. This is, I want to try to steel man this argument. I really do, because I want to try to give this argument every benefit of the doubt, but I'm having a real tough time seeing this as anything but an appeal for a boot stamping on the face of a human forever. I just see it as an oppression. It's okay. Nazi, commie, what's the difference? It's all an authoritarian shit show. Well, thank you for joining me. If you like this, please give it a like, subscribe, and as always, your support is appreciated. Thank you for joining me. Till later. Peace and good night.